SJC-12384, Millis Public Schools v. a minor and others.
Good morning, and may it please the court. My name is Katrina McCusker, Rusteika, and I'm here on behalf of the appellant child. Kids who play hooky, kids who cut class to go hang out with their friends, those are the children that the habitual truancy statute tries to reach. My client, this child, she wants to go to school, but because of her complex set of physical, emotional, and developmental disabilities, she's not able to meet the school attendance requirements. My client shouldn't be branded a juvenile status offender for manifestations of her disabilities. She needs help from the special education process, but she is not a truant.
I'm worried about the definitions, because the judge, obviously, we've never said what willful means, and the judge used Black's Law Dictionary, and I think you agree with his standard? I mean, you want it a little broader. You want more of a causal link between the truancy or the refusal to go to school and the condition, correct?
Yes, I think that one of the things that a judge needs to examine in a truancy CRA is whether there is proof beyond a reasonable doubt that the child's failure to go to school was willful. And I did cite Black's Law Dictionary in my brief, but I would also note that this court has defined willful, and I turn to the case of Commonwealth v. Schuchart. And in that case, the court said that willful means that a person takes first, a voluntary action, and second, that they do so with a specific purpose in mind. And so what I'm arguing is that the truancy statute, for a child to be adjudicated truant, the child must first take a voluntary action to not go to school. And second, the child must have an intent to be truant. She must not go to school because she doesn't want to.
What do you make of the judge's initial response where he continued it twice in order to get services for the child to try to help this situation? And I think the school department as well was trying to help the family out. What do we make of what the judge did to try to resolve this short of a truancy determination?
Well, I don't think that there's, the trial judge wanted to help this child. I think that's clear. Everybody wants to help this child. But the court's authority, the juvenile court's authority in a CRA is incredibly circumscribed. The only authority the juvenile court has in one of these cases is to place conditions of custody on the child or remove the child from her parents' custody. The court cannot make direct orders of services. So the court couldn't help this child.
So that's why the judge found the truancy to set this condition?
Well, actually, the judge said she was setting no conditions of custody. And so I think that in itself is evidence that this was not the right forum for this type of case. But before, that is the disposition. And in the CRA, the statute says the adjudication phase and the dispositional phase should be two separate proceedings, first of all. In this case, they were combined. But to be adjudicated, there must be evidence, proof beyond a reasonable doubt, supported by the subsidiary's findings of fact, that the child willfully failed to go to school.
Can I go back to that definition of willful? Because one of the earlier SJC cases talks about the word willfully, they're talking about in Section 3, does not require the neglect to provide to be done with malevolence or ill will. It is enough if the conduct resulting in the failure to provide was not unintentional. That seems to be a lower not unintentional seems to be a lower standard than the Black's Dictionary definition that you're using, right?
I also found that definition of willful in my research, but that case was addressing the intent requirement of willful and malicious. And malicious goes to the evil intent. Willful on its own, according to this court, has sort of it's a specific intent that you have a voluntary action, and that voluntary action is accompanied by a purposeful intent to achieve that act.
Let me try to shake out the consequences of if we rule in your favor the way you want us to rule in your favor. Here, we have we have a child who wants to go to school who can't go to school, and that's what you lay out in very persuasively in your brief, due to a medical condition and a mental disability, correct?
Correct.
What about a more typical situation where we have a middle schooler who suffers from ADHD and some type of anxiety disorder? Unfortunately, this middle schooler, in my hypothetical, could be bullied. Now, this middle schooler can't go to school, the parents would say, or someone would say, because going to school in the face of what they go through every day increases the child's anxiety, and school is not an option. What should we do? If we adopt your definition, does that child doesn't go to school and doesn't get services and falls behind in school, and that vicious cycle impedes the child's future?
Well, first, every CRA is a fact-based inquiry. So every CRA presents a unique set of circumstances depending on the child. So I'm not arguing that every child with a disability can't be found truant, but the court must find proof beyond a reasonable doubt that the child is acting intentionally to miss school. And I think in the case where you have a child who is being bullied, a child who suffers from severe anxiety about school refusal, sometimes it's called, it may be, under the circumstances, that child could be deemed truant, but there is a more appropriate forum for children who aren't going to school because of disability, anxiety disorders, even bullying. We have anti-bullying statutes, and we have a very complex and established special education process that specifically in the statute expressly talks about students with anxiety disorders and bullying.
Because as I read your brief, you said that the willfulness excludes children who cannot attend school based upon a medical, psychological, or developmental disability, right?
I'm saying that in this case, this particular child, her disabilities
I'm worried about the other cases. I mean, because
Right.
frankly, the child in this case, I think, and the judge agreed, really requires assistance, and this is an incredibly sympathetic and very difficult case. But I'm worried about having a broad-based rule that's going to hamstring people who are well-intended, who want people to be educated, have their constitutional right to free education, as we'll hear about later. But people who want that to have happen, but there's an anxiety disorder, there's a defiance disorder, which are very common in this type of middle school, young adolescent population. So how do we hold in your favor and not swallow those cases?
I'm asking the court to give context to the word willful in the truancy statute. And if a juvenile court judge has to explain how this child willfully failed to attend school, I think that the children who are meant to be captured by the CRA statute will satisfy that. But the children, like this child, who the only reason she is not attending school is because of her disabilities, the juvenile court can't do anything to help her. All it can say to a child in a truancy case is, child, you have to go to school. I will leave you with your parents. Let's see, you need to go to school. But if you don't, I'm going to put you in the custody of the Department of Children and Families.
But here, it wasn't merely a matter of physically going to the Millis schools. They had home tutoring, which she generally rejected most of the time. I mean, how many hours of home tutoring were offered versus how many were actually accomplished?
That's right. She did not complete all of the hours of tutoring that were offered. But prior to the 2016-2017 school year, this child was schooled entirely at home. She was at grade level, she was doing the work. It wasn't until her parents and she decided that she should be exposed to her peers, that she should try to attend school. We know that part of her disability is that she has severe anxiety, and it's exacerbated when there are new, requirements put on her. So everyone acknowledged, including the school district, that to get her to attend school would be a lengthy process. She couldn't just get up and go full-time. She needed to transition. And that's, again, why a CRA is not the right forum for this case.
And here's where I'm confused. So let's assume a child, for various reasons, has schooling because of a severe mental or emotional disability. That child effectively is attending school at home, correct?
Correct.
That child cannot be found truant unless the child is essentially rejecting or not subjecting herself to the tutoring.
Correct. Our special education law, which is a federal law, says that children who are found to have diagnosed disabilities can attend school, can meet the school attendance requirements in a variety of ways, whether it be solely home-based schooling or, a combination of home-based and in-school schooling. That's fine. And again, that's why what should have happened in this case is that if the school district and the parents, disagreed about the method that this child should make her transition into the school, then they should have gone to the Special Education Board of Appeals, who has the authority to order special education services. The Juvenile Court does not.
Was there anything, though, that suggested that they were in disagreement?
Yes, I think that
Said that there should be an appeal to this other forum, but I didn't take from this record anything that suggested that the parents or the child were in disagreement with what was being offered. It was just whether or not she could get herself to do it.
it was my reading of the testimony of the school official that the school was somewhat frustrated with the child's lack of progress, and that they were expecting the child to be attending school, rapidly making the transition from being entirely schooled at home to in school because they were paying for this special placement.
Right, they had placed her outside the school district, and they also had given her an aide to come in the morning to help her out as well?
Yes, that's correct, Your Honor.
But I'm a little bit confused. I did not understand the judge's finding of truancy to be based on her failure physically to attend the Millis schools. I understood him to find that she was failing to attend the educational offerings, many of which were at home, that were offered by the Millis school. What is your understanding?
I agree that it's not clear why, what action of the child's led the court to decide that this child was being truant. I think that the school district filed this petition because the child was not physically coming to school. And so I think that was the primary issue before the judge.
Okay, so what do you do? I mean, again, I have read the judge's findings, but have not gone back to the record. You have a person in this very sad situation who the person shows up at school, Ms. Thomas is here to tutor you for 2 hours, and the student refuses to talk to Ms. Thomas. Is she truant for doing that?
Well, it would depend on the student's intent, and that's
Okay,
the
so
willful
if
piece
the
of
judge,
this.
so if the judge had based his finding on that, we would have to determine that the judge was clearly erroneous in finding that refusal was willful.
The willfulness is not a fact-finding that is proven by a preponderance of the evidence. The CRA statute is clear that the allegations in the CRA petition, the individual allegations must be proven beyond a reasonable doubt.
Okay, so it must,
Does that mean?
I'm meaning that, yes, it is an erroneous conclusion in this case because the evidence simply doesn't even support a preponderance of the evidence burden, but in these cases, it is proof beyond a reasonable doubt.
okay, but
Beyond the reasonable doubt of the facts underlying what it takes to make it willful?
I'm sorry, I didn't hear you.
Proof beyond a reasonable doubt of what?
That the child's actions to fail to attend school were willful.
And so, but that can be clearly erroneous. I mean, we would have to find that the judge was clearly erroneous, and so finding that beyond a reasonable doubt.
And I think that on this record that it was clearly erroneous.
Would it matter if we had a set of parents who have thrown up their hands and say, I just can't do anything, this child is not going to be educated, and there's nothing that I can do to push her or pressure her to do that? Would that affect this finding?
No, in this case, I would say no, because again, the CRA is focused entirely on the actions of the child, and again, it's the intent of the child. On a case-by-case basis, if there are facts that would lead a court to be able to conclude that that particular child is simply not listening to her parents, she just doesn't want to go to school, yes, I mean, that is what the truancy statute is for.
How about if this continues just like this, and we're back here 4 years from now? How old will the child be?
This child is 15, so
Basically, the child will have completed high school without really going to class, if we continue with the pattern we're in right now. Because I think, isn't that what's driving the school a little bit, that they're afraid she's never going to get the education she wants to have? If we do this for 3 years more, is there still nothing that can be done?
there is.
Well, but I'm just trying to understand the consequences of continuing in the status quo, which is, when the Chief Justice asked you earlier how many times she'd actually taken advantage of the homeschool, it was very limited, right? It was only a couple of times for a couple of hours, right?
The in-home provider testified that once they got into a routine, she was actually making most of the tutoring
right?
sessions
Is that
at the
right?
library. Yes, it
Well,
ebbed and flowed. Her attendance ebbed and flowed, and
I'm
once
just, how many hours of education had she had that year?
she only had something like 55 hours.
So if we go for 3 or 4 more years at 50 hours, what's the normal school day hours roughly?
900 plus.
So if we do 50 hours for 3 more years, still not willful, I take it we're in the same position then, right?
Right, again, because the reason that willful is included in this statute, it goes along with the court's overall authority in child requiring assistance cases. The juvenile court could not have ordered in-home tutoring for this child. She couldn't have ordered a behavioral therapist. She couldn't have ordered a specialized therapeutic school placement. She simply could only say to this child, I'm going to take you away from your parents because you're not going to
So the truancy
school.
finding doesn't help access any services?
Correct, Your Honor.
It's a sledgehammer you're saying that need not to be wielded.
Right. I mean, the juvenile status offenses have been Massachusetts law for hundreds of years, and only until recently were they decriminalized, but they're still punitive in nature. They're meant to catch kids who are misbehaving and to divert them before they commit criminal offenses.
So what are the consequences to this child of being designated truant?
Well, we know her medical doctor wrote a note saying that this adjudication has exacerbated her anxiety. It's causing her to not be able to sleep. It's interfering with her ability to progress in her therapies. The threat of being removed from her parents' care at a subsequent dispositional hearing if she's not attending school, affects her, it harms her, and it interferes with her fundamental rights. So there is very real harm to this child by having an adjudication.
So it seems strange to me that we have an adjudication which could permit the state to take a child away from his or her parents, but you're saying that the extent to which the parents have been helpful and supportive is irrelevant to the determination.
CRAs are focused on the behavior and conduct of children. If the conduct of the parents, if it was suspected that the parents were preventing the child from going to school or somehow encouraging her not to, the Department of Children and Families can investigate the parents in a care and protection scenario. That's distinct from a CRA.
I'm trying to sort this out because we don't get many of these. Child here exhibiting the very same behavior. One alternative set of parents is trying everything they can desperately to have the child get an education. Another set of parents has thrown up their hands and says, there's nothing I can do. This child will simply grow up without any learning. Your view is that the state, in making this truancy determination, does not distinguish between those two sets of parents?
If there are parents who are neglecting their child's education, a 51A report of suspected or alleged child abuse and neglect will be filed by the school, and the Department of Children and Families will investigate that neglect allegation.
That wouldn't factor into the judge's decision whether or not to change custody?
It may, Your Honor, it may.
So it's not irrelevant?
It's not irrelevant, but
Because you're saying that's the only thing the judge can really do. You can't order services, you can't change anything else. All you can do is decide who's going to be the custodial, as it were, parent.
that's correct.
So what the parents are like doesn't seem like an irrelevancy in determining whether or not that change in custody is an advisable thing to do.
If, again, on a fact-by-fact basis, each child, each circumstance, the court may consider that. But if the primary issue is the parent's actions, then a CRA is not the correct.
I have a question that you may not know the answer to, but is there something about the procedural posture of this case or the decision of the judge on truancy that explains why there's nobody on the other side of the V here to argue?
I don't know. I do not know why the school district chose not to participate in the appeal.
It's the fact that the parents, I mean, they've done such a good job here, but it seems like in certain ways it hurts them because they've come up with so many different opportunities, none of which have worked and none of which the child has, in your view, willfully avoided. But in certain ways it makes it easier to come to the conclusion that maybe the child is being willful because she's turning down or at least not able to use so many of these options.
Well, I disagree. I think the record establishes that this child was very motivated to try to attend school.
I'm not criticizing the child. I'm just saying the parents have done an excellent job creating one opportunity after another with the school district, but the child's not been able to take advantage of any of them, really.
That's right. And in these cases where special educational services are really at issue, the Special Education Board of Appeals has a fair hearing process in which a hearing officer can order that the child be educated in a different manner or that some other service be tried. That decision can be appealed by the school district or the parents to the Superior Court. And the Superior Court judge has the authority to order educational services. But the Juvenile Court never has that authority in a truancy case. It just so happened that in this case, the school and the parents, as this case was progressing in the Juvenile Court, the school and the parents were on their own accessing services and trying to help this child.
Was there anything in the law requiring the school to move against this child as truant? Did they have any discretion in this?
They do have discretion in who they file a CRA petition because we know that children who have disabilities recognized by the special education system should not be deemed truant. I mean, that goes back to the inclusion of a specific intent in this statute. So school districts shouldn't be able to circumvent the special education process and sort of shift the burden onto the child in these cases.
Okay, thank you.
Thank you.